Good day, Crime Talk aficionados. It is Saturday, May 14th, 2022, which means only one thing. That's right, the weekly recap of all of the top stories throughout the week that we brought you here on Crime Talk, all located in one convenient location. We hope you enjoy it. We'll see you next time on Crime Talk. Who has the advantage with the 1 week scheduled delay in the trial for Johnny Depp and Amber Heard? Well, as we've talked about, Johnny Depp's defamation trial is on a scheduled week-long break after the world listened to a parade of witnesses, including Amber Heard, testifying in recent days last week. Now, Depp is trying to prove to a jury that the actress defamed him in the op-ed she penned for the Washington Post that alleged that she was the victim of domestic and emotional abuse without specifically naming Johnny Depp. Now, Depp's case is no layup for his legal team, all right? And Depp has an uphill battle, in my humble opinion, to win this case and ask and get the $50 million. And why does he have an uphill battle? First of all, anything that was said in the op-ed in Heard's testimony is completely false. That's what they have to prove. Everything that she said is completely false, made up with malice. Because remember, he's a public figure, and truth is an absolute defense to a defamation case. Remember, the op-ed does not state a specific instant or a place or a time that any of this happened. It just generally references being a victim of abuse on the part of Ms. Heard. The attorneys for Johnny Depp are going to try to poke a hole in the testimony of Amber Heard on cross-examination. And this 1 week break is great for them. Certainly they are getting transcripts, if they haven't already received those, or videos of what's taken place in court. And then they can go back in and prepare and literally probably excoriate Miss Heard. But Miss Heard's team also gets the advantage as well, because they get the opportunity to go see how things are being read in the court of public opinion, go back in and try to clean things up that maybe aren't going so great, ask those questions that the court of public opinion is asking, so that they have this time and can clean that up either on continuing direct or on redirect as well. It really helps both parties. But remember, Johnny Depp has to be able to show that never in his life has he ever done anything that could be constituted as domestic abuse under the law. In previous videos, we've given you that law. It's pretty general. It's really something done to an intimate partner with the intent to harass, annoy, alarm, intimidate, exert some power over. We'll see what the jury decides to do. Casey White is back in custody after being arrested in Evansville, Indiana on Monday. Now, his lover, the former correctional officer, Vicky, she died from a gunshot wound to the head after a dramatic police chase, but it's unclear at this point who actually pulled the trigger. Now, as you may recall, Vicky White was supposed to be transporting Casey White, they weren't related, on April 29th from the jail to court, but the pair made a run for it. They managed to dump their car in Tennessee and then evade police for nearly 2 weeks. The pair has been hiding out in Evansville, Indiana since May 3rd, and they dumped their car at a car wash that day. And the owner of the car wash reported their truck to police on May 4th, but the police said they really couldn't do anything. So he had the vehicle towed, and on May 4th and on May 8th, the United States Marshals finally contacted him about the surveillance footage that he had of Casey White at the car wash. Well, guess what? Then the Marshals then tracked the pair to the motel on Monday, followed them in a different vehicle, and like I said, Casey's now in custody, and the sheriff insists he will not be let out of their sight. Now, initially, police said that Vicky White killed herself, and the reason for that was there was some audio of a dispatch call between 911 operators, and it revealed that Vicky told them she was holding a gun to her head and had her finger on the trigger. However, as of today, it remains unclear if she killed herself or if Casey shot her. An autopsy is pending. Now, the Marshals Service noted that when they made the arrest yesterday afternoon, when they were taking Casey White into custody, he said, quote, "Help my wife. She just shot herself," end quote. Obviously, there's an ongoing investigation to determine if that was in fact the case. Now, Casey White's quality of life is going to be very different than it has been. Obviously, there were reports that he was receiving some special treatment from Vicky. Well, he'll be now getting some even more special treatment. But this will usually require every time he comes out of his jail cell, he will be belly chained. He'll have his ankles shackled, and he may even have a stun belt when he goes to court. And I assure you, there will be multiple officers around him at any time he's out of the cell. And the correctional officers will more than likely be also posted outside of his cell, and they will probably be instructed not to speak with Casey White so that they cannot be manipulated by him. Okay, now you may say, Scott, how do you know this? Well, let's just say Scott had experience with a client that was a pretty smooth talker, very manipulative, and was able to get people, including correctional officers, to do things for him because, well, he was that good. And one could argue that maybe Casey White is that good as well. So we will have to wait and see. In this particular case, Mr. White has a trial coming up, and now he's going to have more charges coming up as well. Now, this guy was never getting out of prison. I'm sure he figured, what the hell? And he had that final last touch of freedom before he goes off and spends the rest of his life in prison, where one would say that he is a dangerous person and probably deserves to stay there. Now, we'll see what happens in his upcoming murder trial, where he's confessed but claiming insanity. Somehow I think that defense just went out the window.
Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, Josh Duggar, rhymes with hugger. Well, as you may recall, he was convicted after a trial back on December 9th of 2021. He was convicted of having inappropriate images of minors. That's right. Bad stuff. Okay. He faces up to 20 years in prison. And when somebody is convicted or somebody pleads guilty, then the court orders that the pre-sentence investigation report be prepared. And in the federal system, they call them probation officers, even though no one's really going to ever get probation. Anyway, the probation officer prepares a report. It's all kinds of background information. They also look at the federal sentencing guidelines, and they do a preliminary analysis as to what the appropriate sentence would be under the federal sentencing guidelines, which are advisory and only one factor that the court must consider in conducting the appropriate sentence, making sure that it is a fair sentence, no greater than reasonably necessary, to justify and assure all the principles of sentencing, i.e. punishment, deterrence, rehabilitation, and any other needs that the court thinks the defendant may have. Once that report is prepared, a copy goes both to the prosecution and the defense. The defense can file any objections, as can the prosecution. The prosecution will also file what they refer to as their sentencing memoranda, and then the defense can file their sentencing memoranda. Also, it's known as a motion for variance. The defense in this particular case has filed basically some letters from his family, what I refer to as good guy letters. Well, of course, his mother, his sisters, his wife is going to say he's a good guy. And you know they're really trying to avoid it when they can only come up with stuff like he's a good guy. He's a good dad. He's very diligent and very organized man. He's very caring. Of course, there's no mention of what he did. Now, obviously, like I said, what do you expect other than he's a good guy from their family? Most parents will stand by their children regardless of whether they plead guilty or whether they are found guilty at trial. Such is the case here. Well, the prosecutor is asking for the maximum sentence of 240 months. The defense doesn't ask for a specific date, but says obviously it should be no greater than reasonably necessary for the appropriate sentence and the goals of sentencing under 3553A of Title 18 of the United States Code to keep it as minimal as possible. Sentencing is coming up for Mr. Duggar on May 25th, so we'll find out what the judge is going to do. Obviously, Mr. Duggar went to trial, so he does not get the acceptance of responsibility downward variance as it relates to the federal sentencing guidelines, but he should not receive a trial tax for making the government come forward and present their evidence. And frankly, hey, this is the way the system is supposed to work. Even when people are convicted, it's good for everything to be out there for the world to see. What is the judge going to do? Well, it's early in the prediction dates. We have previously run the federal sentencing guidelines, and I think that given his sentence, referring to Mr. Duggar, that he'd probably be in the 12 to 14 year range for a sentence. Now, the judge doesn't have to give that. He can give all the way up to the maximum sentence, and nothing illegal is taking place at that point. Only if it was greater than the maximum penalty would it be an illegal sentence. What do I think the judge will do? I don't know. If I was the judge, and here we have Mr. Duggar, a father of 7 children and 1 recently newborn, I think the sentence would be something very high on the sentencing range, so that basically he would not have any contact with his children until they were over the age of 18. But hey, that's just what I would do. Let's see what the court does on May 25th. All right, first on the docket, Lori Vallow's extremely complex and fragile mental health. What does that mean, and how did we get here? Well, as you may recall, we talked about it earlier in the week that the prosecution has filed a motion to basically join Lori Vallow's trial date, which is now set for October, with that of her husband, Chad Daybell, which is set to start in early January of 2023. You may say, well, why is that the case? Well, Lori Vallow had been at the state hospital having to be restored or have her competency restored so that she was fit to stand trial. So she did not enter a plea of not guilty at her arraignment as early as Chad Daybell did. Well, Chad Daybell waived speedy trial so that they could set a trial date out into January, which gave everybody time to prepare for trial, even though everybody's had 2.5 years to be working on this case thus far. Well, when Lori appeared last month for an arraignment, she did not agree to waive speedy trial. Under the Idaho Constitution, every defendant is entitled to have their trial within 6 months from the date that they enter a plea of not guilty. Therefore, the judge then set the trial for Lori Vallow to begin in October. The prosecution said, hey, there's this little exception in the speedy trial statute that gives the judge the authority to set a trial date beyond the speedy trial date if there are certain things that would take place, i.e., for example, 1, the defendant wouldn't be prejudiced in any way. It's not a huge delay, and basically it just makes good judicial economy to do that. However, a plain reading of the statute clearly says 6 months. And on a death penalty case, why do you want to mess around on something like that that could get reversed if, let's say, hypothetically, the judge says, fine, I will set Lori Vallow's trial into the next year in January with Chad Daybell. And if Lori Vallow doesn't explicitly waive speedy trial, that is an appellate issue. And if the Court of Appeals said, hey, judge, you shouldn't have done that, guess what? Lori Vallow goes free. She walks, okay? So I keep saying, just let the prosecution go try their case. I keep telling the prosecution, not that they have to listen to anything I have to say, which is just go try the case. If you have to do it twice, go do it. Well, the defense for Lori Vallow, the defense attorneys, have filed a response to the motion to continue. And I think it's worth reading a better part of the motion because it's not that long and it gives some context. And I'll explain what I think it means. And it says, comes now the defendant, and hereby we respond. The defendant has been incarcerated and hospitalized for 2 years since her arrest on February 20th of 2020. She has reviewed with counsel the court's order regarding the joining of her case with her husband, Chad Daybell's case, for purposes of a jury trial. She has reviewed with counsel the court's order denying Chad Daybell's request for separate trials. She has instructed her attorneys not to file a request for a separate trial. Although in custody for over 2 years, Lori Vallow was just arraigned on this indictment on April 19th of 2022, and she had previously hired private counsel when arrested in 2020, but was found to be indigent prior to her hospitalization in 2021. Pursuant to the recently amended Rule 44.3 Idaho Criminal Rules, the trial court did not and could not authorize the spending of public funds for a defense team until she was arraigned. A fully funded defense team at public expense was approved at her arraignment on April 19th, 2020. As the need arises, other experts may be hired for the defense. She, referring to Lori Vallow, has met several times with her defense team, currently consisting of lead counsel, co-counsel, a mitigation specialist, and an investigator. She understands that her defense team is spending a considerable amount of time going through the mountain of discovery in this case in order to get ready for trial. She understands that the defense team is in the process of identifying and interviewing witnesses for the trial and for the potential sentencing if there is a conviction. She understands that the heightened scrutiny in a death penalty potential case. Lori Vallow's mental health is extremely complex and fragile, and she has the potential to be hospitalized again in the near future. None of the experts employed by the court and the state of Idaho Department of Health and Welfare claim she is malingering or making up her mental illness. She understands that she will undergo further mental health testing, as a neuropsychologist approved for the defense team will be meeting with her next month. She understands her right to a speedy trial and does not want to waive that right. If the court moves her trial from October 11th, 2022 to January 9th, 2023, she understands that will give her defense team more time to get ready. So let's read between the lines, okay? Only the defendant can agree to waive speedy trial. Okay? The defense attorneys have said, hey, Judge, even though I've been on this case for a while, Lori Vallow hasn't been arraigned, so I couldn't really dig into it, and I couldn't get a defense team for a death penalty case until arraignment, so I'm a little bit hindered here, and she's only met a couple of times with her attorneys, investigator, mitigation specialist, and her investigator. So they could have worked on the case, but they weren't going to get paid for it. Because that's the rule, right? State money, got to be real frugal with it, right? Not making a whole lot of sense here. They're also putting the court on notice that they are having concerns as to her mental health and her competency, basically by saying it's extremely complex and she has the potential to be hospitalized again. That's the defense team saying, Judge, I know she's back. I know she's competent in the eyes of the court so far, but I'm not so convinced this is going to last, okay? That's what he's trying to telegraph to the court. And he's saying she has been advised that the court wants to join these cases or already has. She's also aware that Chad, her husband, through his attorney, has filed a motion to want a separate trial. She's also aware of the fact that she has a right to a trial within 6 months, and she's not prepared to waive that. But she also understands that if the court continues the trial to January of next year, that'll give her attorneys more time, which is basically the defense attorney saying she won't agree to waive speedy trial. The attorneys need more time to prepare since we're really just getting up to speed, Judge. So although she can't waive speedy trial or won't waive speedy trial, I don't have the authority to do so as her attorney. But if you do it and you come to this conclusion, she's basically okay with that as well, which probably goes to the whole issue of whether she truly understands and appreciates what is taking place, which comes back ultimately to the competency issue. We will have to wait and see. Does the judge say, you know what, I'm just going to extend it. It's going to give everybody a little more time. He'll have to engage in a colloquy, a conversation with Lori Vallow and say, you understand you have your right? You sure you don't want to waive speedy trial? Because I'll give you a trial within 6 months. But I also have this little provision that says I can maybe do it. But guess what? If I'm wrong, it gets reversed on appeal. She walks free. No do-over. That's it. She walks. Why would the prosecution even take that chance? I just don't understand it. Once again, prosecution should say, you tell us where, judge, you tell us when, we'll have our witnesses, we'll have our evidence, and we will prove this case beyond a reasonable doubt. We'll see if the prosecution really wants to risk that. The defense team is basically telling the judge, we've advised her, we need more time, but she's not willing to waive speedy trial. But she's okay with it, which kind of goes back to, does she really understand and appreciate what's taking place here? Can she assist in her defense in making these type of decisions, which goes directly to competency, which they're also indicating that it may be an issue here again really, really soon. All right, there you go. Hopefully that makes sense. Hopefully clear as mud. Before we move on from Lori Vallow, though, a couple of questions that were sent to us that were kind of predominant and basically worth asking. Question is, what is the point of the neuropsychologist after 2 psychiatrists found her competent at the mental health hospital? It's a death penalty case. The neuropsychologist is going to do lots and lots of tests, frankly, more than what would be done when they are determining if somebody is in fact competent to proceed. Why does she have these mental health issues? Was there something that helped cause it? Did she hit her head? Is she diseased? Who knows? There's got to be something that potentially caused the issue. The neuropsychologist, it's all mitigation. Think about it. Everything that could potentially reduce a punishment is mitigation. Whether it's a neuropsychologist exam, mental health issues, psychiatrists, that's all mitigation, which may save her from basically not being put to death if she is in fact convicted. We'll have to wait and see. Second question. Is this filing basically Lori putting the court on notice that she's going to be mentally incompetent again? As I mentioned, I think it is the attorney saying we've got some real concerns, okay? And just because somebody has been found incompetent and then restored to competency doesn't mean that they can basically remain competent. They can fade out of competency, so to speak. I know that's a very technical term there. But the reality of it is the attorneys have a duty. They have an ethical obligation not only to the court and their client to raise that issue at any time that they think that their client may not be competent to proceed. So I think it's the defense attorneys telegraphing to the court, hey, judge, you got to understand the situation that I'm dealing with. I'm dealing with a client that seems somewhat maybe indifferent. Maybe he doesn't understand what's going on. We'll see what happens. The hearing will be held on the 19th. It will be live streamed. We'll be bringing it to you. All right.